Good morning, and I hope this week of preparation has been kind to you, even on the days when the syllabus feels heavier than usual. There is a particular kind of pressure that comes with preparing for an examination that can reshape the entire course of your life. And I want you to know that pressure is not a sign you are doing something wrong. It is a sign you are taking this seriously. This is the Sociology Desk, issue 78. Today we are working with two stories, one on tribal welfare policy and one on a 9-judge Supreme Court bench debating the doctrine of constitutional morality. Both give you thinkers, concepts, and exact language you can carry straight into your answer sheet. Let us start with tribal policy, which sits in paper 2 under tribal communities in India, specifically the subunit on issues of integration and autonomy. This is one of those units that appears almost every year in some form, so you cannot afford to leave it thin. Here is the core tension you must hold in your head for this entire unit. One school of thought, going back to G.S. Ghurye, argued that Indian tribal communities are not isolated primitive societies at all, but backward sections of the Hindu social order who simply need to be brought into the mainstream through education, welfare, and acculturation. Notice what this does. It turns tribal policy into a project of upliftment and assimilation, where the tribal community is a target of schemes, not a self-governing political community. The opposing position says that tribes have distinct cultural and territorial identities, and what they need is not uplift, but recognition, autonomy, and control over their own resources and governance. Keep both positions in your head, because almost every question on this unit is really asking you to place a policy or an event somewhere between these two poles. Now bring in the evidence. A recent audit by India's Comptroller and Auditor General, or the CAG, examined welfare schemes for particularly vulnerable tribal groups in Odisha, and found that over half the eligible population had been excluded. Several flagship projects were lying completely defunct, and monitoring had collapsed. This is exactly what the sociologist T.K. Uman would predict. Uman draws a distinction between an ethnic category, which is just a name on a government list, and a fully recognized ethnic community, which has actual cultural and territorial standing. Being counted is not the same as being recognized. And Partha Chatterjee's idea of political society explains the mechanism of failure. These communities are governed as targets of administrative schemes and funds, not engaged as citizens holding enforceable rights. When you are managed rather than recognized, schemes can quietly fail without anyone being held to account. If you remember only one thinker for this topic, make it Ghurye. In his work, The Scheduled Tribes, Ghurye argued that so-called Aboriginal groups are best understood as backward Hindus who have long existed on the margins of caste society, not as isolated primitive survivals. That sentence, in your own words, is exactly the kind of formulation an examiner is trained to recognize instantly. Write it, attribute it correctly to Ghurye, and then use it as the thesis you go on to critique using Uman and Chatterjee. Now let me put on my examiner's hat for a moment, because this is the slide that actually moves your score. An average answer, the kind that gets you around 14 out of 20, will spend most of its words describing the CAG audit. It will tell the story well, but it will barely touch Ghurye by name, and it will not use the word autonomy or governmentality with any precision. A top answer, the kind that gets 18 or 19 out of 20, does something completely different. It opens with the structural tension between integration and autonomy, not with a definition of tribe. It names Ghurye's concept exactly, attributes it correctly, and only then brings in the CAG audit, in one or two sentences, purely as evidence. It then brings in a counterthinker, Uman or Chatterjee, to complicate the first position, and it closes by proposing a forward looking synthesis. For instance, a shift from welfare targets to rights based recognition. Say it with me, because I will repeat this today. The current event is your evidence, the theory is your destination. Candidates who can sync a news event with the correct concept and the correct thinker are the ones who separate themselves from everyone else in the room. Here is a question to practice on your own. In light of the CAG's findings on the failure of Pvtg welfare delivery in Odisha, critically examine the tension between integration and autonomy in India's tribal policy. Give yourself 25 minutes. And remember, open with the concept, not the news. Our second story takes us to paper 2 again, this time to visions of social change in India, and specifically the subunit on constitution, law, and social change. This is a story about a 9-judge bench of India's Supreme Court, and it gives you one of the most examiner-friendly concepts in the entire syllabus. In April this year, the government's top law officer asked a 9-judge bench to reconsider whether Indian courts should keep relying on something called constitutional morality, the doctrine that helped the Supreme Court decriminalize consensual same-sex relations in the Navtej Singh Johar case, and strike down the colonial-era adultery law in the Joseph Shine case. The government's argument was that this doctrine has no textual basis in the Constitution and lets judges follow their own values instead of the law as written. Now here is where you need B.R. Ambedkar. When he introduced this idea to the Constituent Assembly, Ambedkar was very clear that constitutional morality is not something that exists naturally in Indian society. It is a value that has to be deliberately cultivated, precisely because everyday social morality in a hierarchical society cannot be trusted to protect minorities. That single point, that it is cultivated and not natural, is what most students miss. You can lift this answer further with 3 more names, and I want you to notice how each one adds a different angle. Emile Durkheim distinguished between repressive law, which simply expresses the collective conscience of the group, and restitutive law, which protects the rights of individuals in a more complex, differentiated society. Asking courts to follow majority sentiment instead of constitutional morality is, in Durkheim's language, asking Indian law to become more repressive and less restitutive. Jürgen Habermas gives you the opposite defense, that courts are legitimate when their reasoning is public and deliberative, even if that reasoning runs ahead of majority opinion. And Max Weber's distinction between formal legal rationality, which is bound tightly to the written text, and substantive rationality, which allows ethical content into the law, tells you precisely what the government is asking the court to give up. As Ambedkar argued before the Constituent Assembly, constitutional morality is not a natural sentiment of the people, but a value that has to be cultivated deliberately, often against the grain of existing social morality. Write that sentence into your answer, almost exactly as I have said it. Attribute it to Ambedkar and the Constituent Assembly, not to a random judgment. And you will immediately signal to the examiner that you know where this doctrine actually comes from. Let us do the examiner contrast again, because this question type rewards precision more than most. A 14 out of 20 answer will narrate the story of Section 377 and the adultery judgment in great detail, and mention constitutional morality only in passing, almost as a label. An 18 or 19 out of 20 answer opens with the real question whether law can move ahead of majority social consensus, names Ambedkar's concept with its correct origin in the Constituent Assembly, and uses the 9 judge bench only as the occasion for the debate, in 1 or 2 sentences, not as the main story. It then weighs a counter framework, Weber's formal rationality, or a majoritarian legal position, before closing with a considered judgment rather than a flat conclusion. One more time, because it is worth repeating until it becomes automatic. The current event is your evidence. The theory is your destination. That single habit of mind is what turns a well-informed candidate into a top ranker. Try this one for practice. Is the doctrine of constitutional morality, as invoked by the Indian judiciary, a historically specific construction of post-2018 rights jurisprudence? Or does it have deeper constitutional roots? Comment in about 250 words. Before we close, 3 things to carry with you. First, on tribal policy, Ghurye's assimilationist thesis is your opening move, and Oomen and Chatterjee give you the critique that shows analytical depth. Second, the CAG audit or any current event is only ever your evidence, used briefly, never the main story of your answer. Third, on constitutional morality, remember that Ambedkar described it as a cultivated value, not a natural one. And that is precisely the point being contested before the 9 judge bench today. That is today's brief. Preparing for this examination is a long, often draining process, and the days when nothing seems to stick are just as much a part of it as the days when everything clicks. So keep showing up for yourself, even on the quiet, tiring days. If you would like the complete answer blocks, the model answers, and the examiner notes behind everything we discussed today, drop your email in the comments or write to us at team@upscdesk.com, and our team will share the subscription details with you. I will see you in the next issue.